now said that on the 30th of that section 58, you requires the president's assent on constitutional amendment. So if that's the position of the Supreme Court, it presupposes that the operative section is that still section 58 if he says it's not signing. In that case, we need to come back to the National Assembly, and that only at that level can we override his veto. There will be no need again to go back to the state assemblies. That's my personal view. But I don't think we'll get to that. We're going to persuade the president to sign. He's such a good man, he will sign.
Even when he feels that his interest and the people he represents, being Nigerians, because he's elected by Nigerians, is undermined.
No, I don't think that's unfair to say it's been undermined. Remember that these are passed through 36 states and the two houses of the National Assembly.
Okay,
so let's look at it. Patriotic.
Okay, let's look at it from that perspective. But another issue is the State of the Nation address.
I'm coming to that. I'm not coming to that.
Okay,
I'm going to raise that.
All right.
Okay, so the next is that we separated the office of the Attorney General from that of the Minister for Justice.
Yeah,
that of the Minister for Justice. Same thing will apply at the level of the state. We've also separated the office of the Accountant General of the Federation from that of the Accountant General of the federal government. Now, we've also made a provision for a compulsory State of the Nation address by the President. In the past, I sponsored a bill, called State of the Nation Address Bill. This was in 2010. Eventually, it was passed by two houses of the National Assembly. It was sent to the President. He did sign. So when he did sign, our colleagues were very, very upset and decided to override his veto. But we said, don't worry. What we're going to do is we're going to put it in our constitution, just like most other jurisdictions, including South Africa, Zimbabwe, Ghana, and of course the United States of America. So this time it is now embedded in our constitution. So we expect that the president will once in every year come and address the nation through the National Assembly on the state of nation.
What is the merit of that?
The merit of that is that everybody's expected. In America, it's almost like a celebration. People expect the president to come and say where we are in terms of our economy, our foreign relations, where we are in terms of infrastructure development, what are our challenges, and then the National Assembly will have opportunity to debate it and say these are our own these are our own thinkings, these are some of our perspectives, these are some of the suggestions we have made that will help the nation. So the entire nation will be in the position to understand where we are in very major national issues. So, and everybody looks forward to it in those jurisdictions where this is the practice.
Distinguished Senator, because how would you reconcile this with the New Year address by the President, the 1st October address by the President? Will that, put that aside and just recognize this other one? Because it's still...
Those are discretionary. Even in the Constitution now, the President may attend the National Assembly, may attend our joint sitting, and say anything he wants. That is the authority upon which he comes to present the budget. But it's still discretionary in the way it is coached in the Constitution. But we've never made it now compulsory that in addition to that discretionary provision in the Constitution, in which the President can attend the National Assembly, But this time, it's compulsory now that once in a year, he's expected to address the nation. Let me tell you this. When Yar'Adua was alive, I approached him on that bill. I was excited about it. He was looking forward to be the first president to do it. So regrettably, he died. But when we now passed it, the president was misadvised by some people that would be dragging him to the National Assembly unnecessarily. And I don't believe that. So the president needs to interact with the people of Nigeria as such a huge platform.
Very well. Let's back up a bit, Senator, yes, and discuss again the merits of the separation of the office of the Accountant General of the Federation and then the Accountant General of the federal government.
Yes.
Obviously, states have complained, stakeholders have complained that the fusion of both offices tended, of course, to undermine the efficiency. The same thing with the Attorney General and the Minister of Justice. But I'm just wondering, who will employ the Accountant General, for instance, of the Federation?
Well, it's still the President, because it's an executive appointment.
Yes.
The President will still appoint. But you see, the problem now will be in terms of removal. For you to remove him thereafter, you need to come to the Senate.
Out of control?
Well, he's expected to be independent. So we've tried to create a level of independence, including the funding. So his money is now tied straight down to the Consolidated Revenue Fund, so that he'll be able to exercise a lot of discretion that will be beneficial to the
So how do you put him in check? Because if you say you expect him to be independent, and
we have our public accounts, Committee, in both Senate and the House, same scenario at the state.
So ordinarily, it's the National Assembly that is supposed to
definitely
put them in check.
Definitely.
And the executive cannot make pronouncements with regards to his actions or inactions.
Well, they can, but principally, it's answerable to the National Assembly. That's why we have the Public Accounts Committee provided for in the Constitution. And under our rules, the chairman of such committee must be a member of the opposing party. So that gives that office some level of independence, so that he will be in the position. You see, remember, we're talking about fighting corruption. Yes. So some of these separations we are envisaging will help to deepen the fight against corruption.
Well, I'm wondering, Cliff, I'm just wondering, because this is an important amendment, separating these offices, but you see, there are 3 levels now. 1, appointment; 2, control; and then 3, removal.
Yes.
Now, it's the control that is actually crucial. It's the control.
Removal is a part of the control. Because if you know that the president can hire you and fire you, you have to dance to his tune. The same thing with, it's even worse at state level. But if you know that he can hire you, but he can't fire you, just like the National Electoral Commission, the chairman of Independent National Electoral Commission is usually appointed by the president.
That's true.
But removal becomes a different scenario. The same thing with the CBN. So
given what played out, with the last governor of Central Bank of Nigeria,
yes,
and this scenario you are putting now, don't you think we're going to have some challenges ahead?
No. We're not going to have any challenge. I'm sure Sanusi will be a happy man, that he went the extent he did. He lasted that much, because of that provision, right? He got a point where I'm sure the president would have just removed him, if not for the provision that requires that he has to pass through the National Assembly.
Okay, the next point, Cliff.
Let me take this angle.
Yeah, okay.
Because we're looking at other issues of independence and all that.
Yes.
And considering the lingering crisis with state governors, over release of funds meant for the judicial arm of government. And the current amendment, put them on the first charge.
Yes.
How much, do you think will go to implementing this? Well, the implementability of this very act.
You remember that there was this industrial action, by the judicial workers. It was to get the state governors to implement even the existing provisions of the Constitution in respect of their independence. So we are hoping that with now putting them on the first line charge, maybe some governors, they still not be in a position or in disposition to give them this necessary independence. But now we've armed them with a constitutional provision upon which they can go to court. So we hope and believe that everybody will be responsible enough to implement that. But if that doesn't happen, there is now a provision in the Constitution for which they can enforce their rights to have their monies as a first-line charge under the Consolidated Revenue Fund.
Okay, I would like us again to return to the question of the separation of 2 offices, this time Attorney General of the Federation and the Minister of Justice. Now, obviously, the Minister will be a political appointee. That's fairly obvious, to superintend the ministry and its parastatals. Who will appoint the Attorney General of the Federation? And what will be the relationship of the Attorney General to that of the Solicitor General, who normally is a civil servant? So who will appoint the AG?
Actually, again, the President will appoint the AG, but he can't remove him. I will give him a tenure for 6 years that can be renewed.
Okay.
So that's just the difference. So the president will appoint him, but can't remove him. And he's now going to be completely in charge of criminal division of the Ministry of Justice, essentially. So all these prosecutions, EFCC, ICPC, will now be under the office of the Attorney General. In that case, they can now take initiative to prosecute those in government without any fear that they may be removed.
Are you scrapping the FCC and ICPC by implication?
No, I said that part of the parastatals under him.
Yes.
Unlike the Minister for Justice. Right now, the Minister of Justice, who is also Attorney General, also superintends these agencies.